To discuss a topic that has been in news, the emergency provisions, what, when, why, and its impact. So, when are emergency provisions imposed? How are just checking the live and we will start. Yes. So basically, emergency provisions are given under Part 18, Articles 352 to 360, one of the most controversial provisions of the Constitution of India. I can rightly say that. There is no doubt about it because there have been a lot of criticism. It goes against federal structure. State emergency has been severely misused in India. So now let's understand emergency provisions from the perspective of first that it is a feature of federation unitary feature of Indian Constitution, or you can call it as a feature of federation with a strong center. Federation with a strong center. Now, the question is why is it considered as a feature of federation with a strong center? Because basically, when we have emergency is a situation that is not normal. That is a situation where there is a lot of pressure. You need to take extraordinary measures to restore normalcy. That is the meaning of emergency. So, when emergency situation arises in India, the country assumes a unitary character, meaning all the powers in the country are centralized. The center assumes all powers in the country. So it is considered as a feature with a strong center, a federation with a strong center. It is also a unitary feature because center becomes extremely powerful. The states will be there, but they'll function merely as administrative units. The state government's important decisions can also be taken by the center. Now let's understand emergency provisions from this perspective. I'm sure you must have come across a lot of lectures on emergency provisions, and I'm sure you must have about emergency provisions, when, where, and what. What I'm going to do differently in this class is I'm going to tell you in a comparison about the three emergencies. To begin with, as we all know, there are three types of emergencies. This will actually sum up the whole topic for you. One is called as national emergency, which is given under, and I'm going to explain all this in flowcharts, 352. Okay, followed by state emergency. Please remember there is no term called president's rule in the constitution. The constitution only talks about a state emergency. Okay, and the last being the financial emergency. So these are emergency that is given under 360. Okay, so these are the three articles. Then what about 353, 354, 355, 357, 358, 359? They are also related to emergency, but how is who imposes national emergency under what conditions and what is the impact is basically discussed under 352. Therefore, the article that deals with national emergency is 352. Article that deals with state emergency is 356, and article that deals with financial emergency is 360. Now, moving forward, who imposes all three cases, the answer remains that it is imposed by the president. So, in all three cases, the imposition of emergency is done by the president. Now, the next question is when. Okay, the answer to this is whenever we talk about national emergency, there are two things. Under what grounds? Meaning, what situations can lead to national emergency? What conditions? Please remember the grounds for imposing national emergency could be three. One is war, only if there is a war or war-like situation. Is it necessary that there should be a war to impose national emergency? No. It could be a war-like situation or external aggression, okay, or internal disturbance. Internal disturbance. These three can lead to national emergency. Now, point to be remembered, internal disturbance was there originally in the constitution. It was replaced with armed rebellion by the 44th Constitutional Amendment Act. Why was it replaced with armed rebellion by the 44th Constitutional Amendment Act? Because internal disturbance is very vague. Anything can be considered as an internal disturbance, meaning any situation can be considered as an internal disturbance. For example, you have a large scale protest going on. We had after the Nirbhaya rape case, there was a large scale protest on it. So, if you have a situation like that, that also can be considered as internal disturbance. Whereas armed rebellion is more narrow, it is more specific, it is more defined. Armed rebellion, essentially, when you say arms, it should involve violence or a threat. So, internal disturbance makes it easy to impose national emergency. Armed rebellion makes it difficult to impose national emergency. That is the reason why it has been internal disturbance has been replaced by armed rebellion. Now, the condition has also been imposed by the 44th Constitutional Amendment Act. Originally, when the constitution commenced, there was no condition. Now, what is the condition? You need a written recommendation of the cabinet. Why is this imposed? Because in 1975, when emergency was imposed by the president on the advice of the prime minister, even her own cabinet colleagues, Mrs. Gandhi's cabinet colleagues, were not aware of the emergency. Night, she made them declare. Morning, they came to know about it through the newspaper. So it was that bad. So, written recommendation of cabinet is essential. Here, another important point. Please remember the term cabinet is mentioned only once in the constitution under Article 352. So this is about national emergency. Now let's look at state emergency. State emergency, we have two. One is what are again the grounds for imposing state emergency? What are the conditions for imposing state emergency? Now, when we talk about the grounds, there is only one ground. It is breakdown of constitutional machinery as given under Article 356 directly, breakdown of constitutional machinery in the state. Now, the question is what is breakdown of constitutional machinery? Not defined by the constitution, which is the reason why it was severely misused before the SR Bommai case. SR Bommai versus Union of India case is a turning point, is a milestone, is the most important landmark case related to state emergency in India. It to a large extent had been successful in preventing the misuse of Article 356. In this case, Supreme Court to a large extent tried to define what is breakdown of constitutional machinery. I'm saying tried to define, but there is no formal definition given. It only said what conditions state emergency can be imposed, what conditions state emergency cannot be imposed. For example, in the state, no confidence motion has been passed. Fair enough. Now, do you actually go for president's rule immediately? Because when no confidence motion is passed, the government of the day cannot continue. It loses its majority legitimacy to continue. So the government has to resign. It falls. What is the alternative available? Do you go to president rule directly and then go for elections, or should the governor actually look for an alternative? Is there a possibility that any other political party or group can form a coalition and go ahead and form the government? So, Supreme Court in its judgment says, please look for alternatives. Only when you are assured that there is no possibility of any other party forming a government with majority, then you go for president's rule. Like this, there have been guidelines given in the case, SR Bommai case, which to a large extent prevented the misuse of state emergency. Now, the condition is on the recommendation of governor or otherwise. This is very, very, very important. Now, either the governor recommends or otherwise, meaning even if the governor is not recommending state emergency, president can go ahead and declare emergency. To put it in simple words, governor's recommendation is not mandatory for president to declare state emergency. Governor has the power to recommend state emergency, but it is not compulsory for the president to act only on the recommendation of the governor. Whereas when we talk about national emergency, president cannot impose national emergency without a written recommendation of cabinet. When it comes to state emergency, even without the governor's recommendation, president can declare state emergency. This is very, very important. And remember, breakdown of constitutional machinery is what is given under 356. But 355, Article 355 provides the basis for declaring state emergency. How? It imposes two duties on the union with respect to the states. What are the two duties? One, protect the state from internal disturbances. Two, ensure that the state functions according to the constitution. So, whenever there is an internal disturbance in the state, in order to protect the state, a state emergency can be imposed. Whenever the state is not running as per constitution, the government is not performing its functions as per constitution, state emergency can be imposed. So 355, by imposing two duties on the union with respect to the states, is actually facilitating state emergency. Now moving forward, what about financial emergency? Financial emergency, if the president is convinced that the financial credibility or stability of the country or stability of the country or part of it is threatened, he can declare financial emergency. Remember, for financial emergency, only the ground is mentioned. There are no conditions whatsoever for declaration of financial emergency. This is about who declares, when is it declared. Now, the question is what happens after it is declared. Remember, when it is the national emergency, it has to be approved by parliament within 1 month with the special majority. Okay, this 1 month special majority was actually added by 44th Amendment. Earlier, it was 2 months. It was not a special majority. And remember, this will be applicable for 6 months and it has to be renewed. Okay, it has to be approved every 6 months for extension. Approved every 6 months for extension. Any number of years, 6 months for extension with same special majority. This whole thing was added by the 44th Constitutional Amendment Act. Now, when it comes to state emergency, should this also be approved by the parliament? The answer is yes. This also should be approved by the parliament, and parliament should approve it within 2 months. And when it is approved, it will be in force for 6 months. Again, you get approved. It will be in force for 6 months. Now, it has been 1 year since you have state emergency. Beyond 1 year, you want to extend. Okay, beyond 1 year, then it has to be only under approved only under two conditions. What are the conditions? One, national emergency is also in force. Two, the Election Commission of India declares, gives in writing that the situation in the state is so bad that we can't hold elections. Okay, in only when either of these conditions or situations is met, you can extend it beyond 1 year. Again, beyond 1 year, 6 months at a time. This will be 1 year to 3 years. So 6 months at a time, it can be extended from 1 year to 3 years. 4 times it can be extended. Okay. Beyond 3 years, please remember it can be approved only through a constitutional amendment. If you want to extend it beyond 3 years, you have to amend the constitution for an extension. This entire thing has been again introduced by the 44th Constitutional Amendment Act. See, 44th Constitutional Amendment Act to a large extent try to prevent the misuse of state emergency to a large extent. In fact, all emergencies, national and state emergency, it tried to prevent misuse. It tried to impose conditions and get rigidity within the process so that it will not be misused, so that it cannot be extended forever. So remember, state emergency, 1 year, up to 1 year, there are no conditions. 1 to 3 years, conditionally you can extend. Beyond 3 years, you need a constitutional amendment. So this is about state emergency. What about financial emergency? Financial emergency, the constitution says that within 2 months, parliament must approve. There is no clarification on how many days it will be in force, when should it be reapproved and all that, because till date financial emergency has never been declared in the constitution. In India, it has never been used. 360 remains like a dead letter in the constitution, whereas these have been used. Rather, I would say they were misused. That is the reason why these amendments had to make changes to what was originally written in the constitution. Now, let's discuss the impact of national emergency. Remember, be it national emergency or state emergency or financial emergency, the one organ of government which remains intact, not affected, is judiciary. Judiciary will not be affected because of national emergency or state emergency or financial emergency. Why? Because judiciary is independent in India. Because of its independent nature, there will be no impact on the performance and delivery of the judiciary. Now, coming to national emergency. National emergency, the impact will be Parliament can make law on any subject, can make laws on any subject, including state list, on subjects in state list, because the country assumes a unitary character. That is the reason Parliament can make laws on any subject. Please remember, when national emergency is in force, the tenure of Parliament, Lok Sabha, State Legislative Assembly, may be extended, not compulsory. Extended. Okay. Third, please remember, when national emergency is in force, 19 article automatically suspended if it is on basis of war or external aggression. You don't need a separate presidential order. The minute president says, I am declaring national emergency because of war, 19 stands suspended. Okay. 2021 cannot be suspended. This also was added by the 44th Constitutional Amendment Act. Under any given circumstances, you cannot. And remaining, apart from 19, 20, 21, remaining fundamental rights may be suspended, meaning the president will issue a separate order in order to suspend them. And remember, this is only during national emergency, not applicable during state emergency. And the financial impact of national emergency is the grants and aid that are given to the states by the center may be withheld by the president for that financial year. So, this is about the national emergency. Now, state emergency, what happens? Please remember, when state emergency is imposed, please remember, I'm reiterating, the state government is not dissolved. Constitution does not say state government must dissolve. It says that state government is placed under suspension ab initio, meaning indefinite suspension. Okay, it is under indefinite suspension. While here, state government, we are only referring to executive and legislature because judiciary remains unaffected. Now, what happens to the executive? The work of the executive, as per the constitution, is done by the president. The president will get all the power that the executive, the council of ministers, and the chief minister exercise in the state. It is vested in the president. Therefore, it is called as president's rule. Okay, popularly known as president's rule. Otherwise, on behalf of the president, it is the governor who actually wields power. That is the reason it is also referred, in some cases, it is also referred to as Governor's Raj, Governor Raj, President's Rule. Why President's Rule? Because as per the Constitution, the work of the executive is given to the President. But in reality, who is actually doing the work? The governor. Therefore, it is also called as the Governor Raj. Remember, the work of the legislature is taken over by the Parliament. There is no suspension of fundamental rights, please. Now, financial emergency, maybe, okay, It is not mandatory. Salaries may be reduced, except the President of India. Salaries may be decreased, reduced. Okay. The state may be asked to reserve its money bills for the President's consideration. Maybe. Nothing is compulsory. This is how the emergencies have an impact in India. Now, moving forward, are emergencies good or bad? As Dr. B.R. Ambedkar said, emergency is a necessary evil, necessary devil in the constitution. You cannot do away with emergency provisions because, given India's diversity, given India's porous borders, that with the borders and the issues we have, there are bound to be problems, and there should be a constitutional mechanism to address these situations. So, emergency is a necessary evil in the constitution. However, the people who are going to use it, impose it, have to be judicial enough to understand that it should be imposed only if it is necessary. Unless it is necessary, it should not be enforced. In fact, Baba Saheb also said that Article 356 should remain a dead letter. He wished and prayed that Article 356 should remain a dead letter. What do you mean by this? It should not be implemented. There should not be a situation when Article 356 should have been implemented or could be implemented. However, 356 has been severely misused. I told you about SR Bomai case. So, SR Bomai case is very, very important. It is a landmark case related to state emergency. Now, moving forward, why is it that financial emergency is not declared? Remember, India will never declare financial emergency, not because we are the fourth largest economy. Because when you are declaring financial emergency, it is like putting a board in your neck and saying, "Hey, world, look, I'm bankrupt." Nobody will say that I'm bankrupt. So India will never do it. For that matter, no country should do it because it gives a wrong picture to the world. Your economy will suffer. You will not have any investments flowing into your country. So till date, India never declared financial emergency. This is a quick roundup of about emergency provisions. I hope things are clear to you. Thank you for joining me. I'll come up with another topic tomorrow night. Thank you and bye-bye.